Do you agree with Justice Scalia, who you reference in your brief, that it's never permissible for the government to use race to try to remediate past discrimination, to try to achieve justice?
So I was not.
A lot of people aren't aware of the fundamental part the Supreme Court has in how our society looks and interacts with the concept of race. You see, the judicial branch doesn't just interpret the law. They make law through their decisions and establish what you call a precedent. And no court in this country has greater binding power than the Supreme Court of the United States of America. So when the Supreme Court ruled in 1954 with the Brown versus Board of Education, the segregation was unconstitutional, the promise of Brown was even greater than ever. It promised true racial equality. Before Brown, there was Plessy versus Ferguson, an 1896 Supreme Court case that legalized segregation of public facilities racially. It established the separate but equal principle for 60 years, giving way to the era of Jim Crow laws that enforced racial segregation. It wasn't until the 1950s that a movement emerged to challenge segregation in public schools. In 1951, Oliver Brown filed a lawsuit against the Board of Education in Topeka when his daughter, Linda Brown, was denied access to an all-white school. The case was held before the Supreme Court in 1954, and Chief Justice Earl Warren stated, "In the field of public education, the doctrine of separate but equal has no place," overturning Plessy versus Ferguson and making segregation unconstitutional. Brown helped spur the civil rights movement. A year later, Rosa Parks famously refused to give up her seat. Her arrest led to the historic Montgomery bus boycott, resulting to demonstrations, sit-ins, and a revolution led by the great Martin Luther King Jr. The Civil Rights Act of 1964, Voting Rights Act of 1965, and Fair Housing Act of 1968 aided in ending Jim Crow laws once and for all. This exemplifies the promise of Brown. But Brown had a long, tough road in his journey. It encountered great defiance from states and was followed by subsequent cases that directed how desegregation can be enforced, such as the Swan versus Charlotte Mecklenburg Board of Education case, allowing busing students to desegregate schools, or the 1978 Regents of University of California versus Bach that upheld affirmative action, with the court allowing race to be an important factor to be considered in admissions. We have depended upon cases like these that upheld race-conscious policies, that approved and even encouraged looking at individuals comprehensively. This lets people get quality education and socioeconomic advantages. In fact, on average, students who attend racially and socioeconomically diverse schools perform better than those who attend with high concentrations of low-income students. Diverse schools also decrease racial bias and stereotypes. Desegregated schools also contribute to higher rates of graduation, increase in wages, and low rates of adult poverty. Integrated schools have also shown to reduce achievement gaps, especially when desegregation peaked from the 1970s to the 1980s. But that's just it. It peaked. Segregation has worsened. UCLA conducted a civil rights project research on the issue and showed that integration in the South has been steadily decreasing. They attributed it to legal attacks on desegregation. Court oversight decreased during the 2000s. This might be because of the Supreme Court case Board of Education of Oklahoma City Public Schools versus Dowell in 1981, ruling that federal supervision of local school systems was a temporary measure to remedy past discrimination, and that once a school system demonstrates earnest compliance, courts can remove federal oversight. This led to 45% of school districts removed from court oversight between 1990 and 2009 alone. And segregation only gets worse when school districts are removed from court oversight, taking back the gains and benefits of desegregated schools. And in 2007, the case Parents Involved in Community Schools versus Seattle School District No. 1, or the PICS case, the Supreme Court struck down race-based assignment plans by the Seattle and Louisville school districts that helped to integrate and desegregate. This is a case that lays a precedent for colorblind policies in education by the Supreme Court. It dwells on the idea that to eliminate racial discrimination, we'll pretend it doesn't exist and hope it goes away naturally by ignoring it. Sadly, this is what Chief Justice Roberts noted in his ruling opinion. As the Supreme Court closes their eyes and takes on colorblind policy positions, they might give more leeway for segregation to happen. With the departure of Justice Kennedy, a more moderate judge that was often the swing vote in the Supreme Court, only to be replaced by Brett Kavanaugh, a highly conservative judge, making the conservatives clearly in favor in the Supreme Court. With this, activists for racial equality are understandably concerned for the future. So we need to get ready for the day the court finds an excuse to discourage segregation even more. We need to understand what's at stake for racial diversity with the current Supreme Court and how they can make or break the promise of Brown.